Thank you. Is Mr. Bimbo online too?
May it please, Honorable Court.
Yes.
My name is Oluseyi Taiwo.
Oluseyi Taiwo.
Yes, my lord. I appear for the claimant.
Here's a cost decision. The claimant filed this complaint and statement of facts together with other processes on the 9th day of August 2021 and claims the following reliefs against the defendant. One, a declaration that the payments by the defendant of ex gratia to his affected employees in the event of redundancy is a customary practice of the defendant. Two, a declaration that payments of ex gratia to employees of the defendant in the event of a redundancy is an implied term of contract of employment of the individual employees of the defendant, the claimant inclusive. Three, a declaration that payments of ex gratia in the event of a redundancy is an implied term of the contract of employment between the claimant and the defendant. Four, a declaration that the refusal of the defendant to pay the claimant ex gratia when the claimant lost his job with the defendant on account of redundancy is wrongful and a breach of implied term of contract of employment. Five, an order of court compelling the defendant to immediately pay the claimant the ex gratia sum of 9,837,373 naira 91 kobo, representing the claimant's 13 months gross salaries being the same basis upon which ex gratia were paid to his former colleagues, similarly declared redundant between 2020 and 2021. Six, 4,540,326 naira 42 kobo damages representing the claimant's 6 months gross salaries against the defendant, being damages for wrongful detention of the ex gratia due to the claimant. 7, 1 million naira being the cost of this suit. Or in the alternative one, a declaration that the decision of the defendant to pay ex gratia sums and additional medical allowances to a class of employees who lost their job on account of redundancy, but chose to deny another class of employees affected by the same redundancy, the same benefits, amount to discrimination and unfair labor practice. 2, a declaration that the decision of the defendant to pay ex gratia sums and additional medical allowances to a class of employees who lost their job on account of redundancy, or chose to deny the claimant who equally lost his job to redundancy, the same benefits, amount to discrimination and unfair labor practice. 3, an order of court compelling the defendant to pay the claimant the sum of 9,837,373 naira 91 kobo, representing the claimant's 13 months gross salaries, being the same basis upon which ex gratia were paid by the defendant to the claimant's colleagues, similarly affected by the 2020 to 2021 redundancies. 4, 3 million naira only damages against the defendant, being damages for discrimination and unfair labor practice meted to the claimant. And 5, 1 million naira being the cost of this suit. The defendant filed his memorandum of appearance and statement of defense together with other processes on the 3rd day of November 2021, which were, however, regularized on the 22nd day of November 2021. The claimant filed a reply to the statement of defense on the 2nd of June 2022, which was regularized on the 15th of November 2022. Trial in this suit started on the 20th day of February 2023 when the claimant gave evidence in chief as CW by identifying and adopting his statement of oath filed on the 9th of August 2021. The following documents were tendered by the claimant and admitted by the court. 1. The employment contract in the name of John Ogaji, dated 2nd July 2012, Exhibit CW1A. The pay slip for the month of June 2020 in the name of John Ogaji, Exhibit CW1B. The termination and release agreement signed by Mr. Ogochukwu Chijioke, Exhibit CW1C. The solicitor's letter of hybrid solicitors dated 17th of May 2021, Exhibit CW1D. The solicitor's letter of hybrid solicitors dated 3rd of June 2021, Exhibit CW1E. The solicitor's letter of LX legal practitioners and arbitrators dated 28th of May 2021, Exhibit CW1F. The solicitor's letter of LX legal practitioners and arbitrators dated 9th of June 2021, Exhibit CW1G. The letter of redundancy in the name of Mr. Anthony Nwobodo, dated 13th of August 2021, Exhibit CW1H. The letter of redundancy in the name of Mr. Morakinyo Babatunde, dated 13th August 2021, Exhibit CW1G. The employment termination and general release agreement in the name of Mr. Babatunde Musa, Exhibit CW1K. The certificate of compliance with Section 84 sub 4 of the Evidence Act 2011, Exhibit CW1L. The witness CW1 was cross-examined by the defendant's counsel, Rafik Anama, on the 14th of June 2023, before he was discharged without any re-examination. The claimant's second witness CW2, Juan Desmond Derefaka, who testified in the sister case with suit number NICN PHC 91-2021, identified and adopted his witness statement on oath, which was filed on the 9th of June 2023, with 9 paragraphs as the deposition of the witness with 33 paragraphs, also filed on the 9th of June 2023, was withdrawn and struck out on the 15th of June 2023. The witness tendered the following documents which were admitted by the court. 1. The letter of redundancy in the name of Mr. Chijioke Ekwenze, dated 21st December 2020, Exhibit CW2A. The letter of redundancy in the name of Mr. John Ogaji, dated 29 June 2020, Exhibit CW2B. The letter of redundancy in the name of Mr. Emmanuel Mamu, dated 21st December 2020, Exhibit CW2C. The letter of redundancy in the name of Chijioke Ekwenze, dated 21st December 2020, Exhibit CW2D. The letter of redundancy in the name of Mr. Chijioke Ekwenze, dated 21st of December 2020, Exhibit CW2E. The letter of redundancy in the name of Mr. John Ogaji, dated 29 June 2020, Exhibit CW2F. The letter of redundancy in the name of Jonathan Akponiwari, dated 29 June 2020, Exhibit CW2G. The letter of redundancy in the name of Mr. Jonathan Akponiwari, dated 29 June 2020, Exhibit CW2H. The letter of redundancy in the name of Mr. Anthony Nwobodo, dated 13th of August 2021, Exhibit CW2J. The letter of redundancy in the name of Mr. Morakinyo Babatunde, dated 13th of August 2021, Exhibit CW2K. The letter of redundancy in the name of Mrs. Doris Paul John, dated 29th of June 2020, Exhibit CW2L. The employment termination and general release agreement in the name of Mr. Babatunde Musa, Exhibit CW2M. The termination and release agreement in the name of Mrs. Doris Paul John, Exhibit CW2N. Termination and release agreement in the name of Mr. Raymond Wanko, Exhibit CW2P. Amendment to termination and release agreement in the name of Raymond Wanko, Exhibit CW2Q. Certificate of compliance with Section 84, sub 4 of the Evidence Act was submitted and marked Exhibit CW2R. The witness CW2 was cross-examined by the defendant's counsel, Rafik Anama, and discharged without any re-examination. Suffice it to state that the evidence in chief of CW2, Desmond Derefaka, in suit number NICN PHC 91-2021, including the exhibits and the cross-examination of the witness, was made applicable to this suit and all the sister cases by the agreement of both counsel to the parties. The claimant's third witness is a subpoena witness, Anthony Nwachukwu, an employee of the defendant, who in compliance with the subpoena appeared before the court on the 17th of October 2023. The witness who testified in the sister case with suit number NICM PHC 95-2021 and by consent of both learned counsel had his evidence applied to all the sister cases, produced the following documents, which were admitted by the court as contained in the case file with suit number NICN/PHC/95/2021. The letter of termination of appointment in the name of Mr. Enokon, dated 1st of March 2017, Exhibit CW3A. The letter of employment in the name of Enokon Anekon, Exhibit CW3B. The letter of redundancy in the name of Mr. Anthony Nwogod, dated 13th of August 2021, Exhibit CW3C. The letter of redundancy in the name of Mr. Morakinyo Babatunde, dated 13th August 2021, Exhibit CW3D. The letter of redundancy in the name of Mr. Babatunde Musa, dated 13th August 2021, Exhibit CW3E. The letter of redundancy in the name of Mr. Elioma Ataku, dated 13th August 2021, Exhibit CW3F. The letter of redundancy in the name of Mr. Saloka Kenwi, dated 13th August 2021, Exhibit CW3G. The letter of redundancy in the name of Mr. Ani Christian Ejike, dated 13th of August 2021, Exhibit CW3H. The letter of termination of appointment in the name of Mr. Remedios Ejike Enwere, dated 31st of March 2017, Exhibit CW3J. And the letter of employment in the name of Enwere Ejike was admitted and marked Exhibit CW3K. The witness was discharged, after which both learned counsel urged the court to apply the evidence of the witness in suit number NICM PHC 95-2021 to all the sister cases. The case of the claimants, including the claimant in the instance suit, were closed on the 17th of October 2023 in suit number NICS/PHC/95/2021, which was also made applicable to all the sister cases by agreement of both counsel. The defendant initially opened her defense on the 17th of October 2023 by calling his erstwhile witness Anthony Nwachukwu, who identified and adopted his witness statement on oath that was filed on the 3rd of November 2021, and tendered documents which were admitted and marked exhibits DW1A to DW1D. It is pertinent to note that when it became practically impossible for the witness to appear before the court for cross-examination due to his posting to Saudi Arabia by the defendant with the leave of court called a substitute witness in this suit on the 24th of June 2024. The substitute witness, India Moses Abanu, a quality manager in the employment of the defendant, identified and adopted his statement on oath that was filed on the 13th of May 2024. The defendant then tendered these documents which were admitted by the court. 1. The letter of redundancy dated 29 June 2020, Exhibit DW1A, the termination and release agreement in respect of the contract of 2nd July 2012, Exhibit DW1B, the termination and release agreement in respect of the contract of 1st July 2017, Exhibit DW1C, the termination and release agreement in respect of the contract of 1st July 2017, Exhibit DW1D. The witness DW was cross-examined by the claimant's counsel, Bimbo Atilola, on the 25th of June 2024 and discharged without any re-examination. The defendant closed her case on the 25th of June 2024. Suffice it to add that with the consent and agreement of both learned counsel, the evidence of the defendant's witness, including the exhibits and answers elicited in cross-examination, was made applicable to all the sister cases. With the clause of evidence in the suit, the parties were directed to file their final written addresses. The defendant's final written address was filed on the 8th of October 2024, but regularized on the 16th of October 2024. The claimant filed his final written address on the 27th of December 2024, while the defendant filed a reply on points of law on the 14th of February 2025. These processes were adopted by both counsel on the 4th of April 2025, with Bimbo Atilola appearing for the claimant, while Rafik Anama appeared with Abigail Jua for the defendant. The case of the claimant pleaded and testified that he was employed by the defendant via contract of employment dated 2nd day of July 2012 on a gross monthly salary of 756,721 naira 7 kobo only, according to the claimant. On the 29th of June 2020, during the nationwide lockdown, himself and other colleagues received notice from the defendant to report to the office. In the office, Finance Human Resources Manager issued letters of redundancy plus termination agreement to each of them, which they were mandated to sign, or they would to terminal benefits. And they noticed that terminal benefits payable under the redundancy agreement did not include the customary ex gratia payments, which the defendant customarily pays any employee who is terminated on ground of redundancy. They protested and refused to sign the letters, but the defendant took advantage of their helplessness due to the COVID-19 pandemic and threatened not to pay them their terminal benefits, which made them to sign the said letters. That they signed the termination agreement and other documents on undue influence and economic theories. They pleaded the particulars of the defendant's customary practice of payment of ex gratia in the event of redundancy as follows. 1. Since 2020, the defendant has customarily and habitually paid ex gratia sums to every employee whose employment is terminated on account of redundancy. 2. Between the year 2010 and 2019, the defendant had carried out several redundancies. The customary ex gratia sums were duly paid to the affected employees, regardless of class, grade, union membership, or sex of such employees. And in December 2016, the defendant declared redundancy, which affected one Mr. Anekon Inokon, and consistent with the customary practice in the company. The defendant paid the same Mr. Anekon Inokon the sum of 378,661 naira 40 kobo as ex gratia. And 4, that in March 2017, the defendant also carried out another redundancy, claiming the jobs of its employees, including one Mr. Remigius Ejike Enwere, consistent with the customary practice. The defendant paid the said employee the sum of 335,169 naira 49 kobo as ex gratia. The claimant pleads further that the COVID-19 pandemic gave rise to a series of redundancies carried out by the defendant between April 2020 and May 2021, and that while those of them affected by the redundancy of 2020 were not paid ex gratia by the defendant, sometime between April and May 2021, the defendant let off another set of employees on account of redundancy, and all the affected paid a total of 13 months gross salaries each as ex gratia, including 6 months medical. The habitual and consistent payment of ex gratia to the defendant employees affected by redundancy has become a customary practice of the defendant, and therefore deemed to have been incorporated into the individual employee's contract of employment with the defendant. That in order to formalize the applicable redundancy pay and the customary ex gratia due to the affected beneficiary employees, the defendant entered into negotiations and agreement with the two unions operating in the defendant, namely the Nigeria Union of Petroleum and Natural Gas Workers, NUPEN, and the Petroleum and Natural Gas Senior Staff Association of Nigeria, PENGASA, which made provisions for the 13 months gross salaries as ex gratia payable to all employees affected by the redundancy, including the payment of additional 6 months medical allowance. That the decision of the defendant to pay 13 months gross salaries as ex gratia plus another 6 months medical allowance to a class of his colleagues who were similarly affected by the said redundancy, but chose not to pay him the same benefits is wrongful, and a breach of an implied term of his contract of employment with the defendant, and also amounts to discrimination and an unfair labor practice. According to the claimant, himself and some of his colleagues engaged the services of hybrid solicitors who wrote formal demand letters to the defendant dated 17th of May 2021 and 3rd of June 2021. And the defendant, through her solicitors' letters, admitted paying ex gratia to some ex-employees, but on other considerations as follows. One, that only a very limited number of its non-unionized employees have benefited from ex gratia in the company in the last 10 years. Two, that the claimant and his colleagues are employees not covered under the CBA, portion to which the company made ex gratia payments to the other employees when they declared redundancy. Three, that the claimant and his colleagues were not parties to the CBA under which other employees declared redundant were paid the said 13 months gross salaries as ex gratia. And four, that the company did not also pay any medical benefit to the redundant employees represented by Pengasen and Nopeng, but only increased the ex gratia payment in order to give to those employees an amount equal to the cost of 6 months medical service. Now, defendant's case. The defendant advised that the claimant is an ex-employee of the defendant who was employed on the 2nd of July 2012 as an IT implementation analyst on a monthly gross exit salary of 756,721 naira 7 kobo, less taxes and other deductions. That the claimant's employment was terminated via letter of redundancy dated 29 June 2020, and the claimant also executed a termination and release agreement, and he was paid the total sum of 9,830,088 naira in full and final settlement of all entitlements due from his fixed term employment relationship with the defendant. That at no time was the claimant summoned along with other employees to the offices of the defendant's human resources manager and requested to sign a redundancy/termination agreement as a condition for the payment of his terminal entitlements. The claimant was advised to read and carefully consider all the terms before signing the agreement, and that by clause 4 of the termination agreement, the claimant irrevocably and unconditionally released and forever discharged the defendant from and for any and all liabilities, losses, costs or expenses, grievances, demands, charges, actions, and causes of action whatsoever of any kind and nature, known or unknown, fixed or contingent, that he may have. He also covenanted not to sue the defendant for any claim or demand based on the employment relationship between them, or authorize, encourage, or induce any other person or entity to do so. According to the defendant, neither the claimant nor any other employee who was affected by the redundancy and termination exercise was induced or subtly threatened to sign the termination agreement if he wanted to be paid his terminal benefits, and that the claimant did not protest the terms of the termination agreement or the non-inclusion of any ex gratia payment in the entitlements paid to him by the defendant. The defendant pleads further that it does not have a customary, habitual, consistent, or age-long practice of making ex gratia payments to employees affected by redundancy exercises because of the following. A, the defendant paid ex gratia to Mr. Anekon Inokon and Remedios Ejike Enwere because the employment contracts of these particular two employees did not include the right to be paid end of service bonus in case of termination of the employment relationship by the defendant, which was a recognition that the defendant started to include in the employment contracts of other employees engaged since 2017 under the same terms and conditions. The payments made to Anekon, Enokon, and Remedios Ejike Enwere were therefore payments made under special recognition and not as a habitual or consistent practice. B, in the case of Remedios Enwere, even though his fixed term contract expired in December 2016, the employment relationship continued until 31st of March 2017, and when the company notified him of his termination. He was not paid any gratuity or end of service payment upon his termination. The defendant, however, reconsidered the situation and decided to recognize a special termination payment, ex gratia, as compensation for the lack of recognition of gratuity. This was reflected in the agreement signed with him in June 2017. C, the same situation happened with Enocon, whose fixed term contract, even though ended on 31st of December 2016, his employment relationship was actually terminated on 31st of December 2017. On the 2nd of March 2017, the defender executed an agreement with him to make special payment, ex gratia, as compensation for the lack of inclusion of gratuity in his employment contract. D, in March 2018, when his business operations improved, the defender employed new staff, and this including some ex-employees like Remedios Enwere, who was re-employed, had gratuity / end of service bonus payment included in their employment contracts in the event of termination of their employment before the expiration of the stipulated contractual term or by redundancy or retirement. And E, the special ex gratia paid to each of Enocon, and Remedios Enwere, respectively, was half month's salary per year of service, which was lower than the end of service bonus paid to the claimant upon the termination of his employment. Some other employees, such as Obed Wachuku and Paul Ayu, were also terminated during the period invoked by the claimant and were not paid any ex gratia for the end of service bonus defined in their employment contracts like the claimant. According to the defendant, it does not have a customary or habitual practice of paying ex gratia to ex-employees, and that the payment of ex gratia to an employee is based on specific and exceptional situations at the defendant's discretion. There has to be negotiations with the particular employee before special ex gratia is paid to compensate such omission of payment of an end of service bonus. And this was what the defendant did in the case of Remedios Enwere and Enocon, that the claimant's employment was terminated in June 2020, and no redundancies were paid. No redundancies were carried out by the defendant from January 2021 to May 2021, as alleged by the claimant. Most of the terminations that took place within the period were due to the expiration of the employment contract terms and not due to redundancies. That denies entering into any agreement with the Nigeria Union of Petroleum and Natural Gas Workers, NOPEN, or with the Petroleum and Senior Staff Association, PENGASI, and that no redundancy termination has been done with regard to unionized employees for the period 2018 to 2020, and therefore no ex gratia was paid during such period. The defendant asserts further that he never in his letter of 9 June 2021 admitted paying any usual ex gratia entitlement as asserted by the claimant, and also that the defendant has fully discharged its obligations to the claimant by paying all the claimant's entitlements as stated in the termination agreement, that as an additional incentive to the claimant pursuant to the termination of his employment, the defendant engaged an entrepreneurship and skills development company called the Workforce Group to train the claimant and several of his other colleagues whose employments were similarly terminated on an employability and entrepreneurship skills program, which the claimant actively participated and was given certificate of participation, that the defendant has not breached any implied term of his employment relationship with the claimant. Defendant submissions. The legal counsel for the defendant submitted these 5 issues for the determination of the court. 1, whether this honorable court can rely on the evidence of CW2 in the determination of this action when the evidence was contradicted and completely discredited during cross-examination. 2, whether under the claimant's contract of employment, the defendant has a legal obligation to make an ex gratia payment to the claimant upon the termination of his employment. 3, whether the claimant is stopped or barred from bringing this action by clause 4 of the termination and release agreement, which was mutually agreed between the parties. 4, whether this honorable court can award ex gratia to the claimant based on discrimination, unfair labor practice, and custom. And 5, whether the claimant has by credible and cogent evidence established his entitlement to the relief sought in this action. The learned counsel to the defendant submitted on issue 1 that the evidence of CW2, Desmond Derefaka, who testified as CW2 in all the 9 cases, has been so discredited under cross-examination that it is not safe for this honorable court to rely on same in this suit. Learned counsel reproduced some of the questions and answers elicited from CW2 and posited that while the witness stated in paragraph 2 of his deposition that his employment was terminated because of redundancy, he however admitted under cross-examination that nowhere is redundancy mentioned in his letter of termination as the reason for the termination. Also, while in paragraph 3 of his deposition, CW2 stated that the defendant exerted force to compel the claimant and the other affected former employees to sign Exhibit DW1B, and he had to seek the intervention of the director of the State Security Service, DSS. He, however, recanted under cross-examination that none of the affected ex-staff, including the claimant, stated that the defendant exerted physical force on them to sign Exhibit DW1B. That while the witness had testified under cross-examination that Obed Nwachukwu and Paul Ayu's employments were not terminated on the grounds of redundancy, hence they were not entitled to ex gratia payments. Under further cross-examination on whether the other claimants whose employments were also not terminated because of redundancy were entitled to ex gratia payments, the witness made a somersault and stated that they were entitled to such payments. Again, while in paragraph 6 of the deposition of CW2, he testified that the defendant conducted several redundancy exercises from January 2021 to May 2021, and that Babatunde Musa, Babatunde Murakiyu, and Anthony Nwobodo, among others, were among those that were affected by the exercises. When he was, however, confronted with Exhibit CW2J and CW2K, he admitted that the redundancy exercise, which affected Anthony Nwobodo and Murakiyu Babatunde, was not conducted between January 2021 and May 2021. It was further posited that CW2 is not a witness of truth due to the contradictions in his evidence, that where evidence has been thoroughly discredited during cross-examination, so much that there is nothing left for the purpose of weighing on an imaginary scale for consideration, the court should not give probative value to such evidence. The court was urged to resolve issue 1 in favor of the defendant and declined to ascribe any probative value to the evidence of CW2. With respect to issue 2, learned counsel for the defendant argued that the defendant has no contractual obligation to make any ex gratia payment to the claimant upon the termination of his employment because Exhibit CW1A, which is the contract of employment, does not provide for ex gratia payment. That an ex gratia payment is a gratuitous payment that cannot be enforced, and the liability in law of contract is limited to legal obligations mutually created by parties and does not accommodate gratuitous promises. Counsel referred to the definition of ex gratia in the following authorities: Union Beverages Limited against M.O. Owolabi, and Peugeot Automobile Nigeria Limited against Saliu Oje and 3 others. Citations are provided. Counsel also referred to the Black's Law Dictionary, 8th edition, page 613, which defines ex gratia as, quote, a favor not legally necessary, payment not legally required, end of quote. That an employer has no legal obligation to make ex gratia payments because an ex gratia payment is a gratuitous payment that cannot be enforced, referring to the case of Larson and others against Wema Bank PLC. Citation is given. It was further posited that from clause 3 of Exhibit DW1B, where the claimant acknowledged that he has been paid all entitlements, he is stopped from claiming any ex gratia payment from the defendant. Counsel referred to Section 169 of the Evidence Act, by which a party is stopped from denying the truth of a thing, whereby an existing agreement, he has caused another person to believe a thing to be true and to act upon that belief. And also the case of Attorney General of Nasarawa State against Attorney General of Plateau State. Citation is given. That parties are bound by the terms of their contract, and a party cannot approbate and reprobate at the same time. Counsel referred to BFI Group Corporation against Bureau of Public Enterprises and AG Nasarawa against AG Plateau. Citations are given. The court was urged to resolve issue 2 in favor of the defendant. With respect to issue 3, learned counsel reproduced clause 4 of the termination and release agreement, Exhibit DW1B, and argued that since the claimant confirmed during his cross-examination that he signed Exhibit DW1B and that the defendant has complied with the terms of Exhibit DW1B by paying him all his terminal benefits, the parties are bound by the terms of the agreement. Counsel referred to BFI Group Corporation against Bureau of Public Enterprises, SUPRA, that apart from the absurdity of the claimant that he signed Exhibit DW1B under undue influence and economic duress from the defendant through the HR manager, who allegedly insisted that they will not be paid their terminal benefits if they refuse to sign their respective termination and release agreements. The claimant did not provide any evidence to prove the allegation of undue influence and economic duress. That a presumption of undue influence cannot be inferred in this case because there is ample evidence that the defendant paid the claimant all his terminal benefits as envisaged in Exhibit CW1A and DW1B. Counsel referred to First Bank of Nigeria PSC against Funsho Akyonyo Seye. Citation is supplied. It was further submitted that the claimant's affirmance and evidence are contradictory because while he pleaded in paragraph 9 of the statement of facts that the defendant made it clear to them that anyone who refused to sign the redundancy/termination agreement would not be paid terminal benefits, he contradicted himself in paragraph 11 of the same statement of facts by stating that they were made to sign the redundancy/termination agreement under subtle threat of loss of terminal benefits and economic duress, that a threat cannot be clear and subtle at the same time, referring to the Black's Law Dictionary 8th edition, page 268, which defines clear as free from doubt, sure, unambiguous, and also the Merriam-Webster Dictionary, which defines subtle as difficult to understand or perceive, obscure. These contradictions are also in paragraph 9 and 10 of the claimant's deposition filed on the 9th of August 2021. The court was urged to reject the contradictory evidence of the claimant. Counsel referred to Okereke against the state. Citation is given that since Exhibit DW1B has not been set aside by any court, and the claimant has not asked this court to set aside Exhibit DW1B, same is valid until set aside. That the claimant also failed to provide evidence that the defendant wrongfully threatened his economic interests to compel him to sign Exhibit DW1B, referring to the case of Sadiq against Balarabe. Citation is given. That since all the claimant's entitlements under his contract have been paid, he is not entitled to any additional payments because such claim for additional compensation is not actionable. Counsel referred to Layade against Panapina World Transport Nigeria Limited. Citation is given. The court was urged to resolve issue 3 in favor of the defendant. On issue 4, it was submitted that the court cannot award ex gratia payments to the claimant on the grounds of discrimination, unfair labor practice, and custom, because apart from the averments in his pleadings and his mere absurdity, the claimant did not provide any evidence to prove that the defendant carried out redundancy exercise between April 2020 and May 2021, or that ex gratia payments were made to employees within the set period. That he who asserts must prove, referring to Section 131 of the Evidence Act, and the cases of CPC against INEC and Hillary Farms Limited against MV Mantra and others. With respect to the claimant's contention that ex gratia payment is not contained as an express term in his employment contract, but same is deemed to have been incorporated into Exhibit CW1A as an implied term by custom, habit, and consistent age-long practice. It was posited that a term can only be implied into a contract of employment in order to give efficacy to the express terms contained in the contract and to protect the parties' fundamental rights, which are presumed to have been contemplated by the parties at the time of executing the contract. On this, counsel referred to Afrap Chemical Limited against Owodonyi. Citation is given. That the claimant has not pleaded the particular terms of Exhibit CW1A that the alleged implied term obligating the payment of ex gratia was supposed to give efficacy to, and it is not his case that ex gratia payment is his basic or fundamental right which the parties contemplated at the time of executing the employment contract. Since there is no ambiguity in the Exhibit CW1A, the duty of the court is to give effect to the unambiguous terms and not to rewrite the contract for the parties. Counsel referred to Diamond Bank Limited against Prince Alfred. Citation is given. The parties are bound by their pleadings, referring to the case of Augustine against Humphrey. Citation is also supplied. It was further posited that practices sought to be relied upon by the claimant for the payment of ex gratia are not uniform, consistent, and habitual practices to have earned him entitlement to ex gratia payments. The payment of ex gratia to ex-employees of the defendant was based on individual contracts between the ex-employees and the defendant, because the claimant admitted during cross-examination that the termination and release agreement of Anekon Enokon provides for ex gratia payment. Even DW1 testified in paragraph 12B of his deposition that Remedios Enwere was paid ex gratia based on an agreement signed between the parties in June 2017. That the claimant also admitted during his cross-examination that both his employment contract Exhibit CW1A and his termination and release agreement Exhibit DW1B have no provision for ex gratia payment, and he has failed to produce before the court any other contract between him and the defendant that entitles him to ex gratia payment. That by Exhibits DW1C and DW1D, the defendant has shown that other ex-staff like Paul Ayu and Obed Nwachukwu did not have ex gratia payment clauses in their employment contracts and the termination and release agreement, just as the claimant, and they were not paid ex gratia upon the termination of their employments. That even if the court finds that there was a custom or practice of ex gratia payments, the claim for ex gratia payment is in the nature of special damages, which must not only be specially pleaded with relevant particulars, but must be strictly proved with credible evidence. Counsel referred to Adekunle against UBA. Citation is supplied. And also Order 3, Rule 12 of the Rules of this Court 2017. That the claimant has not pleaded his claim with particulars, nor has he strictly proved said, and it is not the duty of the court to make a case for a party, referring to Piedmont Plywoods against Golden. Citation is given. The court was asked to resolve issue 4 in favor of the defendant and hold that the claimant has not proved his entitlement to ex gratia payment based on discrimination, unfair labor practice, and custom. With respect to issue 5, it was argued that the claimant has woefully failed to prove his case with credible, cogent, and reliable evidence, because he who asserts must prove. Counsel referred to Malambali against Alhaji Nuhu Mekaji. Citation is given. That since the claimant is asking for declaratory reliefs in this suit, the burden of proof is heavier because such declaratory reliefs cannot be granted even on the defendant's admission or default of pleadings. Counsel referred to Senator Iyola Omishore against Ogbeni Rauf Aregbesola and others, and Colonel Nicholas against Mandilas Limited. Citations are supplied. The while reliefs 1 to 4 of the statement of facts are declaratory reliefs, release 5 to 7, which are monetary reliefs, are anchored on the declaratory reliefs. On the alternative reliefs, the while reliefs 1 and 2 are declaratory reliefs, release 3 to 5, which are monetary reliefs, are anchored on release 1 and 2. The failure of the declaratory reliefs also entails that the monetary reliefs must fail, as the court will lack the jurisdiction to grant them. Counsel referred to NDIC against Kolosho and University of Ilorin Teaching Hospital against Abegunde. Citations are supplied. The court was asked to resolve issue 5 in favor of the defendant. The learned counsel to the defendant finally urged the court to dismiss the suit in its entirety with substantial cost against the claimant. Now, claimant's submissions. The claimant's counsel identified the following 6 issues for the cost determination. 1, whether the claimant is entitled to judgment in the absence of a valid and competent evidence by the defendant. 2, whether Exhibit CW2A, CW2B, CW2C, CW2D, CW2F, and CW2G are not sufficient proof of economic duress exerted on the claimant by the defendant to procure the signing of the purported termination or release agreement attached to the claimant's letter of redundancy/termination. 3, whether based on preponderance of evidence, payment of ex gratia to employees affected by redundancy is a customary practice of the defendant, hence an implied term of the redundancy policy of the defendant. 4, whether based on preponderance of evidence, the claimant who is affected by the 2020/2021 redundancy does not have a legitimate expectation interest in ex gratia payments. 5, whether the claimant has proved his case to be entitled to the relief sought. And 6, whether the decision of the defendant in paying ex gratia sums benefits to a class of employees who lost their job on account of redundancy in 2020/2021, but chose to deny another class of employees, including the claimant herein, affected by the same redundancy, the same benefits, amount to discrimination and unfair labor practice. It was submitted on issue 1 that since the defendant's counsel admitted during cross-examination on the 24th of June 2024 that he signed his witness statement on oath at his lawyer's office, the said witness statement on oath is incompetent and liable to be expunged, having not been signed before a commissioner for oaths. That the witness is a man of full age, capacity, and well-educated, and therefore certain of his testimony. A voluntary admission is the best evidence, and even if he subsequently appeared before the commissioner for oath after signing the deposition in his lawyer's office, the fundamental irregularity cannot be cured. That the legal implication is that the defendant has no evidence on record to challenge the case of the claimant, and the pleadings of the defendants are deemed abandoned. The same fate befalls all the exhibits tendered by the defendant. On this, counsel referred to the case of Buba and another against Mahmoud and another, Daniel against INEC and others, and Wurbo against Ahmed. Citations are supplied. It was further argued that the evidence of DW1 is hearsay and unreliable because the witness admitted during cross-examination that his employment letter was issued by a company known as Tenaris, and also that he was not an HR staff of the defendant, that he did not play any role in the 2020/2021 redundancies, and that his testimony was based on the information he received from the HR department. Counsel referred to Section 37 of the Evidence Act and the case of Ali against State. Citation is given. With respect to issue 2, it was submitted that the various letters of redundancy issued to all the claimants in all the suits, which are in evidence as Exhibit CW1H, CW1J, CW2A, CW2B, CW2C, CW2D, CW2E, CW2F, CW2G, CW2H, CW2J, DW1A, and DW1B are proofs of economic duress exerted on the claimants by the defendant, that the defendant took advantage of the uncertainties and seeming hopelessness presented by the COVID-19 pandemic to dictate his threat that if the claimant and his colleagues refuse to sign the agreement, they will not be paid their terminal benefits. Learned counsel reproduced Exhibit DW1A, which is the letter of redundancy issued to the claimant by the defendant, and submitted that the use of the words, quote, "you must previously execute," unquote, in SVDW1A denotes compulsion, which made the signing of the attached termination and release agreement a condition precedent to payment of terminal benefits due to the claimant. That in law, contracts executed under element of compulsion, including economic duress or undue influence, is null and void and unenforceable, thereby rendering the provisions of Clause 4 of the termination or release agreements signed by the claimant and his colleagues, which seek to bar them from filing this suit, to be null and void. That economic duress occurs where a contract is procured under a threat or fear of economic hardship or financial loss, and which exercise prevents the exercise of free will by the party at a disadvantaged position. Economic duress is any form of threat, actual or subtle, to a party's financial or economic interests, and it is a vitiating element in the law of contract. Counsel referred to the Black's Law Dictionary 8th edition at page 543, and also the cases of Universe Tankships against National Workers Federation and Deems Car Shipping against International Works Federation. These are English cases and citations are provided. On issue 3, Learned Counsel reproduced section 16 sub 1 of the Evidence Act and argued that in law, customary practice can be deemed as a governing law, that the customary practice of paying ex gratia to some ex-employees affected by redundancies by the defendant from 2010 to date, regardless of class, age, grade, trade union membership, or sex, is so known in the defendant company, and has formed an implied term of the contract of employment of the claimant. By Exhibit CW3A, CW3B, CW3K, and CW3J, ex gratia payments were made to Mr. Enokon and Mr. Remedios Ejike Enwere, even when both of them had a fixed term contract with no provision for ex gratia. That the defendant also paid 13 months gross salaries as ex gratia to other employees similarly affected by the 2020/2021 redundancy, as can be gleaned from Exhibit CW3C, CW3D, CW3E, CW3F, CW3G, and CW3J. This was admitted by the defendant in their solicitor's letter, Exhibit CW1F, wherein they admitted that the defendant paid ex gratia to other employees similarly affected by the 2020/2021 redundancies, though the payments were based on the specific provisions of the contracts of employment of the said employees. That an admission by counsel binds the client, referring to the case of Adewumi against Plastex Nigeria Limited, and Ogboru and another against Oduaga and others. Citations are supplied. The law is tried that a documentary admission is the best evidence because of its permanent nature. See Odubawu against FSDH Securities Limited. Citation is supplied. That since in law, a term may be implied into a contract by custom and practice, the defendant's customary practice of paying ex gratia to his employees affected by the redundancy over the years is deemed to have been implied into the defendant's redundancy policy and may be invoked by other employees of the defendant. See Bobo against British Airways PLC. On issue 4, Learned Counsel posited that the defendant's customary practice of paying ex gratia to employees affected by redundancy creates a legitimate expectation interest for the claimant to expect to also be paid the same ex gratia when he was declared redundant by the defendant. That expectation interest, which is a reasonable expectation of a benefit, relief, or advantage that may flow or arise from a representation of an entity or its established customary practice, is a right recognized in labor and employment law, and the principle has been applied by this honorable court in the cases of Patrick Modilem against UBA, Ahmed Ishola Akonde against Lilygate Nigeria Limited, Pascal Tamonomi George against Keystone Bank Limited, and Medical and Health Workers Union of Nigeria against Federal Ministry of Health. Citations are also applied. That the claimant and his colleagues affected by the 2020/2021 redundancy have legitimate expectation interest in ex gratia payment based on the previous established practice of the defendant. The court was asked to resolve issue 4 in favor of the claimant. On issue 5, it was submitted that the claimant has proved that he is entitled to ex gratia sum of 9,837,373 naira 91 kobo, representing his 13 months gross salaries, being the same basis upon which ex gratia were paid to his former colleagues, similarly declared redundant between the same 2020 and 2021. The court was urged to grant reliefs 1 to 5. On relief 6, for the sum of 4,540,326 naira 42 kobo as damages for wrongful detention of the ex gratia due to the claimant, it was submitted that general damages require no proof and are granted by courts as the direct and natural consequence of the wrong complained of. The quantum is awarded at the discretion of the court, having regard to all the circumstances of the case, including the nature and gravity of the misconduct. See Mohammed against IGP, citation is given. On relief 7, for the sum of 1 million naira only, being cost of this suit, Learned Counsel referred to the provisions of Order 55 of the rules of this court 2017 and posited that this honorable court has the power to award costs because the claimant and his colleagues in the sister suits were constrained by the actions of the defendant to engage the services of a legal practitioner to file the instant suit. That since cause follows event, the court should grant the relief. With respect to the alternative reliefs, Learned Counsel submitted with respect to issue 1 that it is in evidence that the defendant paid ex gratia sums to certain class of employees who lost their job on account of redundancy during the 2020/2021 redundancy declared by the defendant, but denied the claimant and his colleagues the same redundancy benefits, that the defendant discriminated against them and treated them unfairly, contrary to the provisions of the International Labour Organization Convention number 111, Discrimination, Employment and Occupation Convention 1958, which was ratified by Nigeria on the 2nd of October 2002 and domesticated via Section 42 of the Constitution. That the term unfair labor practice refers to practices that do not conform to best practices in labor, as may be enjoined by local and international experience. It also consists of acts in employment relationships that are considered unjust, inequitable, oppressive, and unconscionable, including grave breaches of employees' rights. It is a discriminatory and unfair labor practice for an employer to refuse to pay ex gratia, an ex-staff the benefits paid to his contemporaries who were previously retrenched in similar circumstances like him. Counsel referred to Mix and Beck against NUFBTE, Darlington Eriseye against Keystone Bank Limited, and Mbilitem against Unity Capital Assurance PS. Citations are also applied. With respect to issue 2, relating to the alternative reliefs, it was argued that the claimant is entitled to the reliefs having proof sent that since employment discrimination is a serious issue deserving huge damages, the court should grant the alternative reliefs in the suit. It is apposite to state that from paragraph 12.0 to 12.17, pages 28 to 34 of the claimant's final written address, the Learned Counsel to the claimant responded to the arguments/submissions in the defendant's final written address. With respect to the submissions at paragraph 4.3 to 4.4 of the defendant's final written address, it was submitted that both parties are in agreement that all the claimants had their employments terminated on account of redundancy. The only fact in issue between the parties is whether the defendant customarily pays ex gratia in the event of redundancy, as in this case. The redundancy is a question of mixed fact and law to be determined by the court based on the evidence before the court. Hence, the fact that the word redundancy is not stated in the letter of termination is irrelevant. That the fact that CW2 had a fixed term contract is also irrelevant because the claimant has demonstrated that the defendant customarily pays ex gratia even where the employment contract is for a fixed term, such as paid to Mr. Anekon Enokon and Mr. Remigius Ejike Enwere, constantly referred to Mola Amasham against Wekombe College. On the submissions, at paragraphs 4.5 and 4.6 to 4.9 of the defendant's final written address, it was posited that the case of the claimant is built on economic duress, that by exhibit CW3, CW3C, CW3D, CW3E, and CW3F, some of the redundancies, including that of Anthony Nwobodo, Babatunde Morakiyu, and Babatunde Musa, Christian Ani, and Saloka Kenwi, and others were carried out at different times in 2021, and the usual ex gratia were paid to the affected employees. That since the termination of employment of Obed Nwachukwu and Paul Ayu were regular terminations not based on redundancy, which refers to disengagement of employees due to excess manpower, they were rightly not paid ex gratia upon their exit from the service of the defendant. With respect to the submissions, at paragraph 4.13 of the defendant's final written address, it was argued that as a general rule, ex gratia is unenforceable, except where it can be shown that same has over the years become a customary and habitual practice of an employer, as held in the case of the registered trustees of Union Bank Pensioners Association against Union Bank of Nigeria, PSC, and others. Citation is given. That the case of Larson and others against Wema Bank, cited by the defendant at paragraph 4.18 of the defendant's final written address, is distinguishable from the instant suit because the claim of discrimination on ex gratia was disallowed by the Court of Appeal because same was never pleaded or canvassed at the lower court. Constantly referred to Mrs. Florita Chinwelu Egulam against Keystone Bank Limited. Citation is supplied. On the submissions of at paragraphs 4.20 to 4.21 and 4.27 of the defendant's final written address, it was argued that the claimant and his colleagues cannot be stopped from claiming ex gratia payment based on the purported termination and release agreement because the document was vitiated by economic duress. That since the termination and release agreement is a standard form document unilaterally drafted by the defendant and foisted on the claimant, same should be treated with caution by the court due to lack of equal bargaining powers in employment relations. The court was finally urged to grant the relief sought by the claimant and his colleagues in this suit and all the sister cases. Defendants reply on points of law. It is pertinent to note that the defendant filed a reply on points of law on the 14th day of February 2025. It was submitted that since the claimant did not respond to the defendant's submissions in paragraphs 4.1 to 4.11 of its final written address, that the court cannot rely on the evidence of CW2 because it was contradicted and completely discredited during cross-examination. The argument is deemed to be considered. The court was urged to disregard the entire evidence of CW2. Counsel referred to Wanko against Yaradua. Citation is supplied. On the submissions of the claimant, in paragraph 5.1 to 5.1.8 of the claimant's final written address, that the evidence of DW1 is incompetent because it was not signed before a commissioner for oath. It was replied that the cases cited by the claimant and the decision of this court in the case of Mr. Ndubueze Alaniwe against First City Monument Bank are distinguishable from the instant case because the court did not take cognizance of the fact that the evidence elicited during cross-examination that the depositions were signed in the lawyer's office were not supported by pleading and therefore inadmissible evidence, which ought not to have been relied upon by the courts, that parties are bound by their pleadings and evidence not supported by pleadings brought to no issue, and vice versa. That since the claimant did not plead the issue of where DW1 signed his deposition to enable the parties joint issues on it, the evidence of DW1 that he signed his deposition in his office is worthless and cannot be relied upon by the court in the determination of this suit. Counsel referred to Madam Jane Reid Aweni against Apostle Joseph. Citation is given, and Akekuta and others against Nuruddin and another, as well as Mrs. M. Adama and others against Kogi State House of Assembly and others. Citations are all provided. See also the Shell Petroleum Development Company of Nigeria Limited against Chief Joy Amaro and 12 others. And Philip Nwakoga Kwaza against Jishida Plastics Industries Company Limited, where this honorable court refused to invalidate a witness statement on oath because the witness testified under cross-examination that he signed the deposition in his lawyer's office, just as in this case. That a witness statement on oath is different from an affidavit, because while an affidavit becomes admissible evidence upon deposition before the Commissioner for Oaths, a witness statement on oath does not become admissible evidence until the witness is sworn and adopts it in court. Hence, a witness statement on oath that is not adopted can be deemed as abandoned. That the witness statement on oath of DW1 became effective and admissible evidence when DW1 affirmed before the court on the 24th of June 2024 in the manner provided by Section 8 of the Oaths Act, and adopted it as his evidence in chief. Counsel referred to Akero Dolu against the registered trustees of government and others. Citation is given. And Basiru Obanigba and another against Jimo Olopo, Abibu and another, as well as Alpha against INEC. Citations are also applied. That since it is the Oaths Act and not the Evidence Act that regulates the form and manner of the witness statement on oath, any non-compliance with Section 112 of the Evidence Act cannot invalidate the witness statement on oath. By Section 4 sub 2B and C of the Oaths Act, any irregularity cannot render the evidence inadmissible or invalidate the court proceedings and can be waived by the court in the interest of justice, pursuant to Section 12.2 of the Evidence Act. This should be the National Industrial Court Act, 2006. On the contention of the Claimant's Counsel that paragraph 5.1.5 of his final written address, that since the witness statement on oath of DW1 is incompetent, the suit is undefended because the defendant's pleading is deemed to be abandoned. It was posited that the evidence of DW1 is competent and should be countenanced in this suit, that even if the evidence of DW1 is invalidated, the court will still be unable to enter judgment for the claimant Desmond admitted during cross-examination that he was paid his terminal benefits, even though he did not sign his termination release agreement. The economic duress and undue influence do not render a contract void, but voidable, and until set aside, the contract remains valid and binding on the parties, says Sadiq against Balarabe. With respect to the submissions, at paragraph 7.2 of the claimant's final written address, that he has proved that the defendant has a customary practice of paying ex gratia to employees that are affected by redundancy. It was replied that the claimant did not provide any evidence before the court to show the defendant's alleged customary practice of ex gratia payment to employees affected by redundancy since 2010, which has now crystallized into a custom that he who asserts must prove, referring to Section 131 of the Evidence Act and the cases of CPC against INEC and Hillary Farms against MV Matra. The defendant has shown that the payment of ex gratia was contractual. Even the payments to Anekon Enokon and Remedios Enwere were based on the parties' agreement and not mutual practice as argued by the claimant. That from clause 3 of exhibits CW3C, CW3D, CW3E, CW3F, CW3G, and CW3H, the ex gratia payments to Anthony Wambodo, Murakiyo Babatunde Musa, Eleoma Ataku, and Saloka Kenwe, and Ane Christian Ejike were contractual and not based on custom or habitual practice. On the claimant's contention, at paragraph 7.4.5 to 7.4.7 of his final written address, that by the solicitor's letter exhibit CW1F, the defendant admitted paying ex gratia to other employees affected by the 2021 redundancy. It was replied that the defendant, by exhibit CW1F, not only denied categorically paying ex gratia to all affected employees as a customary practice, but also clarified that ex gratia payments were made to only those that were paid based on their contracts of employment. That apart from the letter of employment, a contract of employment is also governed by any other document that is introduced into the employer-employee relationship during the subsistence of the relationship, referring to the case of Skybank PSC against Adedokun Adegun, citation is given. On the contention of the claimant, at paragraph 8.1 to 8.5 of his final written address, that the payment of ex gratia by the defendant to other employees affected by the redundancies created a legitimate expectation interest that he will be paid ex gratia when his employment was terminated by redundancy. It was implied that the claimant's case is not founded on legitimate expectation interest, but on a customary practice, breach of implied time, and discrimination, as well as unfair labor practice. The parties are bound by their pleadings, and the party cannot make a case for himself, which he did not make in his pleadings. See National Insurance Corporation of Nigeria against Power and Industrial Engineering Company Limited, that the doctrine of legitimate expectation interest applies to employment relations, where an employer, by his actions or inactions, in the absence of a written contract, creates a state of affairs that gives an employee an expectation which is rational and reasonable, then such employer is by law obliged to meet the expectation. The defendant did not create any legitimate expectation interest that the claimant will be paid ex gratia upon the expiration of his employment contract. Counsel referred to Amit Ishola Akonde against Lilygate Nigeria Limited. Citation is given. The legitimate expectation interest is hinged on the unjustified withdrawal of benefits from a person who has previously enjoyed the benefits and which he had legitimately expected to continue enjoying, thereby causing him injury, referring to the case of Diamond Petroleum International Limited against Governor Central Bank of Nigeria and others, as well as Chinyere Stitch against Attorney General of the Federation, and Medical and Health Workers Union and others against Federal Ministry of Health. Citations are supplied. That in this case, the claimant's claim of ex gratia is not a vested right, and since he had not previously enjoyed the right, a legitimate expectation interest cannot be created in his favor. With respect to the claimant's arguments at paragraph 10.2 to 10.6 of his final written address, that the defendant's non-payment of ex gratia to him is discriminatory and contrary to the International Labour Convention number 111, Discrimination, Employment and Occupation Convention 1958, and constitutes an unfair labor practice for being inconsistent with best practices in labor circles. It was implied that the claimant failed to comply with Order 14A, Rule 1 Sub 1 of the Rules of this Court 2017, which mandates the claimant to plead and prove the international protocol, convention, treaty, or best practice, and states same in his statement on oath, that since the claimant neither pleaded the convention number 111, Discrimination, Employment, and Occupation Convention 1958 in his complaint, nor stated in his witness statement on oath, the court should disregard the submissions at paragraph 10.2 to 10.6 of the final written address because the arguments are of no moment. The court was urged not to place reliance on the English case of Mola against Wekombe College and cited and relied upon by the claimant in paragraph 12.5 of his final written address because it is a foreign authority and the claimant did not furnish the court with a certified true copy of the case for scrutiny. The court was urged to dismiss the case with substantial cost against the claimant. Now, cost decision. I have poured over the pleadings, the entirety of the evidence led by the parties, the written submissions and authorities cited by the parties in their addresses filed in this suit. Having evaluated the entirety of the evidence, I have seen that the issues crafted by the parties for determination are prolix because most of the points of law raised can be considered in the course of considering the claimant's issue 1 and issue 4, which is the same as the defendant's issue 5. The suit shall therefore be determined on the basis of these two issues. 1, whether the claimant is entitled to judgment in the absence of a valid and competent evidence by the defendant. 2, whether the claimant has proved his case to be entitled to the relief sought. The gripe of the claimant with respect to issue 1 is that the witness statement on oath of the defendant's witness is incompetent and should be discountenanced because the witness admitted during cross-examination that he signed the deposition in the office of the defendant's lawyer and not before the commissioner for oath or any person authorized to administer oath. That once the deposition of the witness is discountenanced, the defendant's pleadings will be bereft of any evidence and therefore deemed to have been abandoned. The court was therefore urged to strike out the defendant's pleadings in defense of the suit and enter judgment in favor of the claimant on the unchallenged evidence. Also, that since the witness is an employee of a company called Tenaris, his evidence is hearsay and inadmissible in evidence. In resolving this issue, I have seen from the court records that during the cross-examination of DW, India Moses Abanu, on the 25th of June 2024, the following ensued between the claimant's counsel and the witness. Question: your witness statement on oath you adopted yesterday, was it signed in your own office or your lawyer's office? Answer: it was signed in my lawyer's office, not my office. It is obvious from the witness's answer reproduced above that he made his statement on oath in the office of the defendant's lawyer before same was brought to the registry of this court and then commissioned by Anselm U. Ejiogu Esquire, principal registrar. The legal position before now was that such witness statement on oath sworn in the office of a lawyer or any person not authorized by law to take such oath is incompetent and should ordinarily be discountenanced by the court. That was the opinion of this honorable court. In the case of Mr. Ndubueze Alanewe against First City Monument Bank PSC, suit number NSCM PHC 16-2014, delivered on the 28th of September 2021, wherein this honorable court relied on the cases of Unity Bank PSC against Zamfara State Compulsory Free Universal Basic Education Board and the decision of His Lordship Mbaba Jessie in the case of Kennedy N. Nwokolobi against Japheth Ejemeli and another, and discountenanced the witness statement of the claimant, which was not signed before the Commissioner for Oaths. Let me state that since the decision was made, the position would seem to have changed to the position that the oath taken by the witness and adoption of the deposition in open court rectifies whatever error in the witness statement on oath. In the case of Engineer Emmanuel Anene against Point Engineering Limited, suit number NICS/YEN/165/2016, delivered on Friday, 22nd of November 2024. This honorable court held as follows: held the view that, and I quote, since the rules of procedure upholds ambush on the opposite party, the time to raise objection to such defective deposition is very crucial in deciding whether such deposition should be jettisoned by the court or not. It has been held that such objection to a defective witness statement on oath should be raised early enough for the witness before the witness is allowed to adopt the deposition, and certainly not during final written addresses. This legal position will seem to be in tandem with the desire of this court to do substantial justice to parties and avoid technicalities as envisaged under Section 12 sub 2B of the National Industrial Code Act 2006 and Order 5 Rules 3, 4, 5, and 6 of the Rules of this Honorable Court 2017. See the case of Abdurrahman Yekini against Alhaji Olaya Ibrahim, where the Court of Appeal, Patonde Oyebanji Owotoye JCA, held as follows: with respect to the proper time to object to a statement on oath for having been made in a place other than the office of a commissioner for oaths. In my view, the witness statement on oath of PW1 was signed at OLAC on 14th of May 2019. The witness under oath adopted the said statement without objection. I adopt the reasoning of my noble lord, Patricia Mahmoud, JCA, in registered trustee of Roman Catholic Mission of Archdiocese of Onitsha and others against Edozionu Sopra, which I consider sound and binding on me. The deposition wrongly sworn to is defective and can be set aside before adoption on oath by the deponent. An oath adopting the deposition by deponent has a sanctifying effect of an oath validating an oath on the witness deposition, thereby curing it of its defect. For clarity's sake, I hereby reproduce a statement of Patricia Mahmoud, JCA, in Edozionu Sopra. If counsel has any objection to the regularity of a witness statement, the proper time to raise it and draw the attention of the court to the said irregularity is at the point the witness seeks to adopt said as his evidence. Once adopted, the witness statement transforms to the evidence in chief of the witness, and every objection to its regularity becomes of no moment, and I will therefore not dwell on it any further. This point has been repeatedly made by this court in a good number of cases, quite distinguishing between affidavit evidence and witness statements. In the case of Okpa against Eric and another, this court held as follows: the tribunal rejected the tendering of the witness statement on oath as it did not conform with the requirements of Section 13 of the Oath Act. This court has consistently held that the witness statement on oath is different from an affidavit evidence. An affidavit is a statement of fact which the maker or deponent swears to be true to the best of his knowledge. It is a court process in writing, deposing to facts within the knowledge of the deponent. It is a documentary evidence Transport Corporation against Forum Consortium Supra, both dealt with an affidavit and not witness statement on oath, so they are not relevant. In this case, issues were not joined on where and before whom the statement on oath of the first respondent was sworn to, so the answer given under cross-examination goes to no issue because it cannot support any paragraph of the appellant's pleadings, and therefore it is worthless. Furthermore, there is a presumption of regularity of the witness statement on oath on the face of it, see section 168 sub 1 of the Evidence Act 2011. If the appellants wanted to make it an issue, they should have challenged it by way of pleading. I also resolve issues 5 and 6 against the appellant, end of quote. In the circumstance, I find no merit in this ground of the objection of the learned counsel to the claimant, and same is hereby discountenanced. On the ground of the objection that the evidence of the defendant's witness is hearsay and should be discountenanced because he is an employee of a different company called Tenaris, and he did not play any role in the processes leading to the declaration of the claimant redundant. Let me state that the witness stated clearly at paragraph 1 of his witness statement on oath that he is a quality manager in the employment of the defendant. He merely gave his address as Tenary Yard, Oil and Gas Free Trade Zone, Federal Terminal, One, River State. Even during the witness introduced himself as a quality manager for Pipe Porters Nigeria Limited. During the cross-examination of the witness on the 25th of June 2024, the following ensued between him and the claimant's counsel. Question: tell the court your educational qualification. Question: tell the court your educational qualification. Tell the court your educational qualification. Answer: I have a bachelor degree in engineering from University of Benin. Question: you are a staff of Tenaris. Answer: I am a staff of Pipe Porters Nigeria Limited. Question: your contract of employment was issued by Tenaris. Answer: yes. Question: you are a manager in the quality department. Answer: yes. Since there is nothing before the court to show that the witness does not work for the defendant, I do not think it will be fair hearsay, having shown that he works for the testified for the defendant, because by virtue of his position as a quality manager, he is expected to have access to any information relating to the instant suit. I do not see how his evidence, as deposed in his witness statement on oath filed on the 13th of May 2024, amounts to hearsay, in view of the fact that the defendant, being an artificial person, can only be represented by one of its officers. In any event, Section 12, Sub 2B of the National Industrial Code Act 2006 and Order 5 Rule 6B of the Rules of this Court 2017 allow this court to depart from the Evidence Act in the interest of justice. Fairness, equity, and fair play. See the case of Mr. Victor Adegoyu against UBA, citation is supplied, where the Court of Appeal applies Section 12 sub 2 of the National Industrial Code Act 2006 and departed from the provisions of the Evidence Act 2011. This may also be an appropriate case to depart from the Evidence Act, particularly Sections 37 and 38 thereof, in the interest of justice, fairness, equity, and fair play, and I so depart. Issue 1 is therefore resolved against the claimant, and the court shall countenance and place reliance on the deposition of the defendant's witness in this suit. With respect to issue 2, let me state straight away that the claimant's case is not in the main challenging the termination of his employment by way of declaration of redundancy by the defendant. From the state of his pleadings and the reliefs in the suit, he is simply asking the court to hold that the non-payment of ex gratia to him, even when the defendant paid other ex-employees who were also declared redundant in 2020 and 2021, is discriminatory and unfair labor practice, and for the court to order the defendant to pay him the sum of 9,837,373 naira 91 kobo, representing his 13 months gross salaries as ex gratia. I therefore agree with the contention of the defendant's counsel that the claims in this suit are in the nature of special damages, which the law places the burden on the claimant to prove same by specially pleading and strictly establishing his claims. See sections 131, 132, 133, and 134 of the Evidence Act and the case of Gonzi Nigeria Limited against Nigerian Educational Research and Development Council and others. Citation is given, where the apex court held, and I quote, strict proof in the context of special damages means that the person making the claim in special damages should establish his entitlement to that type of class of damages by credible evidence and such character as will satisfy the court that he is indeed entitled to an award under that head. See Oshinjirin and others against Alhaji Elias and others. Dumex Nigeria Limited against Ogboli. End of quote. See also the decisions of the Court of Appeal in the cases of Federal Capital Authority and another against MTN Nigeria Limited against ACFC. Claimant pleaded his monthly gross salary at paragraph 4 of the statement, which entitles him to payment of ex gratia at paragraph 13 of the statement of facts. During the cross-examination of the claimant at CW1 by the defendant's counsel, Rafik O. Anama, on the 14th of June 2023, some of the high points of the answers as stated from the claimant are that he was employed by the defendant on the 2nd of July 2012 as an IT implementation analyst, and affirmed that his contract of employment does not contain an ex gratia payment clause, but that it is a customary practice for the defendant to pay ex gratia as his colleagues were paid. He affirmed that his letter of employment contains all the terms and conditions regulating his employment with the defendant, but that other benefits were given to him which are not in the letter of employment, that his employment was terminated via letter of redundancy dated 29th of June 2020, which took effect from 30th June 2020. He further affirmed that following the termination of his employment, he entered into a termination and release agreement with the defendant dated 30th June 2020. He also affirmed that under the termination and release agreement dated 30th June 2020, his full benefits in the sum of 9,830,088 naira was calculated and paid to him less lawful deductions. That while it is correct that the termination and release agreement dated 30th June 2020 does not contain an ex gratia payment, it is, however, a customary practice for the company to pay ex gratia to employees who are leaving the company on the basis of redundancy. That he is aware that one Yenagoa he mentioned as one of the persons who were paid ex gratia by the defendant has an ex gratia clause in his agreement. That while it is correct that by the termination and release agreement, he agreed with the defendant that they settled with finality and released each other from all claims and demands that he may have or may arise out of his employment or termination of his employment by the defendant. He was, however, made to sign the letter under economic duress because of the pandemic, as the condition for the payment of his severance package was that he must sign the document. He, however, affirmed, being aware that some persons did not sign the agreement, but they received their payments, that his letter of redundancy was given to him by the then HR manager during an impromptu meeting with the HR manager and his line manager. He affirmed not being present when the other claimants signed their letters of redundancy, and also that he was not a unionized employee because he was neither a member of Pengasin nor Nupeng. The evidence in chief of the claimant's second witness, CW2, Desmond Derifaka, is as contained his deposition in suit number PHC 91-2021. The parties agreed that his evidence in chief and cross-examination, as well as the exhibits, should apply to all the sister cases, including the instance suit. During the cross-examination of CW2 by the defendant's counsel, Rafik and Hamman, some of the answers elicited from CW2 are that even though he was given letter of redundancy by the defendant, he, however, refused to accept it, that he was issued with a letter titled End of Contract of Employment, by which his employment with the defendant was terminated. He affirmed that it is not indicated in the letter that his employment was terminated by reason of redundancy, but that he was informed orally that it was redundancy. He also affirmed that it is not all the claimants on whose behalf he made a deposition that their employments were terminated by reason of redundancy. He affirmed being the Derifaka Desmond referred to in paragraph 3 of his deposition, and also that he stated that he called the DSS to intervene when the defendant was trying to use force on the ex-employees to sign the termination and release agreement. He further affirmed being aware that none of the claimants on whose behalf he testified said that the defendant used physical force on them to sign the termination and release agreement. He affirmed referring to Obed Nwachukwu and Paul Ayu, not Paul Aliu, and that since the employment of Paul Ayu was not terminated by reason of redundancy, the payment of ex gratia does not apply. That all the claimants whose employments were not terminated by reason of redundancy are entitled to ex gratia payment. He further stated that the defendant carried out redundancy exercise from January 2021 to May 2021. I mentioned the names of Babatunde Musa, Babatunde Morikayo, and Anthony Nwabodo as the persons affected by the redundancy during the period of January to May 2021. He mentioned the dates on exhibit CW2J and CW2K as 13 August 2021 and affirmed that the redundancy in exhibit CWK and CW2J were not carried out between January 2021 and May 2021. I have equally looked at the pleadings of the defendants, including the evidence in chief of the defendant's sole witness, DW, India Moses Abanu, via the witness statement on oath filed on the 13th of May 2024. Some of the high points of the answers elicited from DW during his cross-examination by the claimant's counsel, Bembo Atilola, on the 25th of June 2024, are that he has a bachelor's degree in engineering from the University of Benin. He refuted being a staff of Tenaris, but that he is a staff of Pipe Porters Nigeria Limited. He, however, affirmed that his contract of employment was issued by Tenaris and that he is a manager in the quality department, that by the company procedure, HR does not administer the signing of redundancy documents, but gave the name of the HR manager at the time of the redundancy termination process to be Umuze Omonigo Jeprie, who worked with both Tenaris and Pipe Cutters Nigeria Limited. That the documentations for the redundancy process were available for him, and the HR manager also briefed it, and that the employees of Pipe Cutters are in different categories, and some of them are unionized under Nupeng and Pengasin, that he had worked as quality manager of Pipe Cutters Limited for over 4 years and 5 months, and also that while there is a CBA for the 2021 redundancy, he is not aware of any redundancy in 2020. He affirmed that since there was no redundancy in 2020, nobody was declared redundant in the year. In response to the question whether the defendant had been paying ex gratia to non-unionized staff in the past, the witness answered that in the past, ex gratia was paid only in special circumstances for the non-unionized employees, but that the unionized employees get ex gratia and other benefits like medical allowances, etc., because it is stated in the CBA that as far as he knows, the benefits that accrue to unionized employees also accrue to non-unionized employees. While I have seen that the defendant is contending strenuously that the claimant is not entitled to the reliefs in the suit because the employment letter, Exhibit CW1A, does not contain any provision for the payment of ex gratia. Let me, however, make the point that the fact that the claims for ex gratia payments are hinged on alleged customary practice is itself conclusive of the claimant's realization that the claims are not part of the express terms of his employment with the defendant as contained in Exhibit CW1A. It is on that basis that he is urging the court to hold that the defendant's customary practices of paying ex gratia to ex-employees affected by redundancy. Such practices have been implied into the terms of his employment. There is therefore no basis to exert so much energy and judicial time on what is not really in contention, going by the nature of the claims and released before the court. The contentions on whether economic duress was exerted on the claimant to sign the redundancy letter without a provision for ex gratia payment, and whether the defendant discriminated against the claimant, and allegations of unfair labor practice, and whether the claimant has a legitimate expectation interest, can only be considered after the court has determined the gravamen of the suit, which is whether the claimant has established that he is entitled to ex gratia payment on the ground of customary practices by the defendant's payment of ex gratia to other ex-employees affected by redundancies and excluding the claimant. Let me first make the crucial point that the claims for ex gratia are in the main gratuitous claims, thereby placing the higher burden on the claimant to prove his entitlement to them, while the Judicial Law Dictionary, second edition, by B.P. Ishaku, at page 148, defines ex gratia as, quote, out of grace, favor, or indulgence, gratuitous, a term applied as a favor, end of quote. The Black's Law Dictionary, 10th edition, at page 694, on the other hand, defines ex gratia as, quote, by favor, made as a favor or gift, and not because of any legal duty, not legally necessary, end of quote. And ex gratia payment as, quote, a payment not legally required, especially an insurance payment not required to be made under insurance policy, end of quote. In the case of Peugeot Automobile Nigeria Limited, against Saliu OJ and 3 others, citation is supplied. The Court of Appeal stated thus on claims for ex gratia, and I quote, what is an ex gratia? Exhibit 2 has not assigned any definition to the term. The term is Latin. It connotes something given out of grace, favor, indulgence, or gratuitous. Henry Campbell Black, author of Black's Law Dictionary, defines it as a term applied to anything accorded as a favor, as distinguished from that which may be demanded ex debito, a matter of right. So it follows that ex gratia payment being claimed by the respondents is a payment by one who recognizes no longer obligation to pay. The way payment for ex gratia is couched in Exhibit 2, as reproduced above, appears to be binding on the appellant and therefore mandatory. On a closer examination, however, it is clear that for the payment of such ex gratia, 2 conditions must be satisfied. 1, that it is only payable at end of the year, and 2, its payment is dependent on the extent to which the production target and other company results have been achieved. Where any or both conditions above is lacking, the company appellant cannot effect payment of any ex gratia to any employee. However, in his process of reasoning, the learned trial judge, who adjudged the respondents entitled to the ex gratia payment as the respondents worked in 1986, from January to 3rd November 1986, a period of over 10 months, appellant ought to pay the ex gratia to the respondents, as whatever target was made in production for the year 1986 was made with the sweat of the plaintiffs. Fine, that may be so, but that is not speculative. That may be so, but is that not speculative? Is that not an indication towards moral consideration? I think the echelon principle of the law, that law and morality are almost always poles apart, is still very much alive. The truth in this this case is that payment of ex gratia is tied to the end of the year, which in normal calculation is the 31st day of December of each year. So unless where the company decides to pay ex gratia to some employees at a time different from end of the year, an employee whose employment ceases before end of the year is not in any way entitled to the company's payment of ex gratia. The respondents were declared redundant on the 3rd day of November 1986. They were not therefore entitled to the payment of ex gratia for the year 1986. That is the true position. Privileges limited against MA Olabi citation is supplied. It is supposed to, at this moment, go back to the issue of whether the claimant has established his entitlement to the claims for ex gratia payment on the basis of customary practices, which have led to the claims forming an implied term of his contract of employment. Section 16, 17, 18, and 19 of the Evidence Act provides for the proof of custom as follows. 16A, a custom may be adopted as part of the law governing a particular set of circumstances if it can be judicially noticed or can be proved to exist by evidence. Sub 2, the burden of proving a custom shall lie upon the person alleging its existence. Section 17, a custom may be judicially noticed when it has been adjudicated upon once by a superior court of record. 18 sub 1, where a custom cannot be established as one judicially noticed, it shall be proved as a fact. Sub 2, where the existence or the nature of custom applicable to a given case is an issue, there may be given in evidence the opinion of person who will be likely to know of its existence in accordance with Section 73. Sub 3, in any judicial proceeding where any custom is relied upon, it shall not be enforced as law if it is contrary to public policy or is not in accordance with natural justice, equity, and good conscience. Section 19, every fact is deemed to be relevant, which tends to show how, in particular instances, a matter alleged to be a custom was understood and acted upon by a person then interested. End of quote. As follows, with respect to any opinion as to the existence of general custom. 73.1. When the court has to fight the opinions as to the existence of such custom or right, or persons who would be likely to know of its existence if it existed, are admissible. Sub 2, the expression general custom or right includes custom or right common to any considerable class of persons. End of quote. In the case of the registered trustees of the Union Bank Pensioners Association against Union Bank of Nigeria, PSC, and 2 others, citation is supplied. This honorable court, by Honorable Justice J.D. Peters, held as follows with respect to proof of custom for payment of ex gratia, and I quote, the nature of the relationship between the claimant and the defendant is clear and not in contention. Exhibit DW1 conveyed the approval of the defendant for the payment of 13th month ex gratia payment to the pensioners, to the claimant. That exhibit was dated 20 September 1988. By the first paragraph of that exhibit, it was apparent that the defendant did not on its own volition suddenly wake up and approve the payment. Exhibit D1 referred to the previous correspondence. That exhibit also indicated that the 13th month ex gratia is payable on the same date as serving staff, referring to Exhibit D2, PAN Limited against OG and others. Is a good authority for the proposition that ex gratia connotes something given out of grace, favor, indulgence, or gratuitous. It, however, seems to me that previous discussions between the parties, which Exhibit D1 referred to, and a reference to Exhibit D2 by Exhibit D1 changed the name of that payment, notwithstanding that it was tagged ex gratia. The reference to previous correspondence aptly indicates that there was a demand for the payment of the 13th bond by the claimant. The eventual approval and issuance of Exhibit D1 further indicates the meeting point by the parties on the payment and how it was to be effected. Now, in PAN Limited against OJ Sopra, the Court of Appeal quoted with approval the definition of ex gratia as given by Henry Campbell Black, author of Black's Law Dictionary, when he defines the term as a term applied to anything accorded as a favor, as distinguished from that which may be demanded ex debito, a matter of right. The demand for same is an indication on the part of the claimant that it was entitled to payment of same. I find and hold that the claimant indeed demanded the payment of the 13th bond pay from the defendant, and that the discussions and correspondences between the parties culminated in the defendant communicating Exhibit D1 to the claimant. Secondly, I have evidence before me that the defendant consistently paid and claimant also consistently received regularly the 13th month pay for a period spanning over 2 decades. The payment commenced in 1988, was suddenly brought to an end in December 2011, a period of 23 years, and or a tradition of the defendant, a practice to be accepted as custom or tradition. It must have been practiced for a fairly long period of time. In the instant case, the practice of payment of 13th month pay has been consistently and regularly uninterrupted for a period of 23 years. In Chief Loveday, Ebere, and others, John Oyenye, the court stated that acceptability and habit of compliance by the people so affected. A period of 23 years is long enough for the court to hold a particular practice to have become a custom of the people concerned. In the instant case, there is evidence that 13th month pay has been paid consistently, regularly, and uninterruptedly. I thus find and hope that that practice, having been carried out for a long time, has become a custom between claimant and the defendant, to such an extent that a party may seek its enforcement, as in the instant case, through judicial process. It is considered custom is not static, but rather elastic, in that it responds to social, economic, and indeed technological changes and development. In other words, what was accepted as custom, even within labor and industrial regime, may cease to be so accepted. It is, however, for the party contending against same to adduce sufficient evidence to report the acceptance or continued prevalence of that custom, end of quote. In the instant suit, the claimant is placing reliance on the payment of ex gratia in the sum of 378,661 naira 40 kobo to Mr. Anekon Inokon in December 2016. The payment of the sum of 335,169 naira 49 kobo to Mr. Remedios Ejike Ewere as ex gratia in March 2017, as well as the alleged payment of ex gratia to employees affected by the 2021 redundancy as evidence of customary practices of the defendant to pay ex gratia to employees affected by redundancy. I have carefully considered the exhibits in the suit and seen that while the claimant's letter of redundancy and the termination and release agreement, both dated 29 June 2020, exhibits DW1A, DW1B, CW2B, and CW2F have no provisions for the payment of ex gratia from the redundancy letters and termination and release agreements of Anekon Inokon, Remedios Ejike Enwere, and Annie Christian Ejike, Mr. Saloka Kenwi, Mr. Anthony Nwobodo, Mr. Morakinyo Babatunde, Mr. Babatunde Musa, and Mr. Elioma Ataku, exhibit CW3A, CW3C, CW3D, CW3E, CW3F, CW3G, CW3J, and CW3H, that the defendant made provisions for and paid them ex gratia of different sums when their appointments were terminated by reason of redundancy, while the appointments of Anekon, Enokon, and Remigius Ejike were terminated in 2017, the claimant and his colleagues who had their appointments terminated in 2020 were not paid ex gratia, but those whose appointments were terminated in 2021, all for reason of redundancy, were paid various sums as ex gratia. It is this ex gratia payments to other ex-employees who had their appointments terminated by reason of redundancy in 2017 and 2021, and excluding the claimant and his colleagues who also had their appointments terminated by reason of redundancy in 2020, that the claimant alleges customary practices as implied term of the contract, as well as discrimination and unfair labor practice. Let me, however, make the point that the claimant is claiming the sum of 9,837,373 naira 91 kobo as his 13 months gross salaries, not 13th month salary, ex gratia allegedly the basis upon which those who were declared redundant between 2020 and 2021 were paid. It is obvious from the evidence before the court that apart from the ifsaid digit of the claimant at paragraph 18 of his deposition, that ex gratia is paid on the basis of 13 months gross salaries to those affected by redundancy. There is nothing before the court to substantiate this very vital and crucial aspect of the claim. If the claimant, if he had either prayed the court to order the defendant to calculate and pay him redundancy benefits without asking for a specific unsubstantiated sum, the court would have taken a different viewpoint. But having specifically asked for 13 months salaries as ex gratia, the onus is on the claimant to establish same, which he has obviously failed to prove. I took the pains of taking a random sample of the ex gratia payments to some of those affected by the 2021 redundancy, and seen, for example, that while by Exhibit CW3E, the monthly gross salary of Mr. Babatunde Musa was 277,656 naira 92 kobo times 30 months will be 3,609,539 naira 96 kobo. He was, however, paid ex gratia of 2,637,257 naira 53 kobo. From Exhibit CW3F, the gross pay of Mr. Eleoma Ataku was 347,168 naira 49 kobo times 13 months is 4,513,190 naira 37 kobo. He was, however, paid the sum of 3,391,550 naira 95 kobo as ex gratia. From Exhibit CW3G, the gross pay of Mr. Saloka Kenwe was 212,598 naira 68 kobo times 13 is 2,763,782 naira 84 kobo. He was, however, paid 1,965,075 naira 1 kobo as ex gratia. And from Exhibit CW3C, the gross pay of Mr. Anthony Nwobolo is 364,676 naira 83 kobo times 13 is 4,740,998 naira 79 kobo. He was, however, paid 3,426,915 naira 47 kobo as ex gratia. There is therefore no justification for the claim of 13 months gross salary as ex gratia before the court. I have also seen that the claimant is basing the 13 months gross salary as ex gratia on the alleged collective bargaining agreement, CBA, entered into between the defendant and the Nigeria Union of Petroleum and Natural Gas Workers, NOPEN, and the Petroleum and Natural Gas Senior Staff Association of Nigeria, PENGASI, as pleaded by the claimant in paragraph 19 and 20 of the statement of facts, which form his evidence in chief at paragraph 19 to 20 of his deposition. The defendant clearly denied the existence of any collective bargaining agreement, CBA, at paragraph 16 of the statement of defense. The said CBA is not before the court, as it is not part of the documents tendered by the claimant or any of his colleagues before the court. The non-production of the CBA before the court to enable the court ascertain the basis for the claim of 13 months gross salary as ex gratia has not helped the case of the claimant in any way. To agree with the evidence of the claimant, viva voce, that he and his colleagues are entitled to 13 months gross salary as ex gratia on the strength of a collective bargaining agreement between the defendant and No Pain and Penkerson, without having the opportunity of perusing the CBA, will only amount to a conjecture or speculation. In the case of Rumrik Nigeria Limited against Federal Republic of Nigeria, citation is supplied. The apex court in the country held that it is not the duty or function of a court of law to act within the realm of conjecture or to speculate. See also Barrister Yenagoa, Yenagoa and others against Governor of Imo State and others, where the Supreme Court, Pakekere Ekun JSC, now CJN, held as follows, and I quote, "It is settled law that the court cannot speculate on the existence of any evidence or the content of a document not before it, no matter how close what it relies on may seem to be on the facts." It was held by this court in the case of Yenagoa against Bazoye and another, Isonguyo against the state, that speculation is not an aspect of inference that may be drawn from facts that are laid before the court. Inference is a reasonable deduction from the facts, whereas speculation is a mere variant of imaginative guess, which even where it appears possible, should never be allowed by a court of law to fill any hiatus in the evidence before it. End of quote. I have also seen a paragraph 10.2 at page 25 of the claimant's final written address that the claimant is placing reliance on the provisions of the ILO Convention number 111, Discrimination, Employment and Occupation Convention of 1958 as the basis for the claim of discrimination and unfair labor practice by the defendant. While this honorable court has the jurisdiction to apply the convention by virtue of section 254C1F, H, and sub 2 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and section 76 of the National Industrial Code Act 2006, the point must however be made that the claimant is by law expected to plead and prove his entitlement under the convention. Order 14A of the Rules of this Honorable Court 2017 provides as follows, and I quote, Order 14A, Rule 1, Sub 1, where an action involves a breach of or non-compliance with an international protocol, a convention, or treaty on labor, employment, and industrial relations. The claimant shall in the complaint and witness statement on oath include A, the name, date, and nomenclature of the protocol, convention, or treaty, and B, proof of ratification of such protocol, convention, or treaty by Nigeria. Sub 2, in any claim relating to or connected with any matter, the party relying on the international best practice shall plead and prove the existence of same in line with the provisions relating to proof of custom in the Extant Evidence Act. End of quote. I have painstakingly gone through the entirety of the claimant's pleadings and witness statement on oath, and not seen where the claimant pleaded and gave evidence with respect to the ILO Convention number 111, Discrimination, Employment and Occupation Convention 1958, having failed to plead the convention in either the statement of facts or the reply to the statement of defense. I hold that the claimant cannot rely on same in his final written address. The law is banal that the address of counsel, no matter how alluring and brilliantly written, cannot take the place of evidence. Courts are only bound by the evidence on record, not address of counsel, which is not supported by evidence. See the case of Mazi Okudili, Nwa Anyajike, and another against Independent National Electoral Commission and another. Citation is supplied. Having failed to prove his claim for 13 months gross salary as ex gratia under custom and implied term in his contract of employment, I hold a firm view that the allegations or contentions of economic duress, discrimination, unfair labor practice, and legitimate expectation interests are all odious and of no moment. The main claim for customary practices of paying 13 months salaries as ex gratia in the event of redundancy must be proved first before the allegations of discrimination, unfair labor practice, and whether the claimant has a legitimate expectation interest could be considered. I so find and hold. In the final result, issue 2 is therefore resolved against the claimant, and the case of the claimant first for want of proof. The suit is accordingly dismissed. It is apposite to note that the hearing of this case on the 4th of April 2025, both learned counsel for the claimant and the learned counsel for the defendant prayed and urged the court to adopt or apply the arguments in this suit to the sister cases. This judgment shall therefore abide or apply to the other 8 sister cases with suit numbers NICN PHC 89-2021, NICN PHC 90-2021, NICN PHC 91-2021, NICN PHC 92-2021, NICN PHC 93-2021, NICN PHC 94-2021, NICN PHC 95-2021, and NICN PHC 96-2021. Judgment is entered accordingly. I make no order as to cost.
The court please. My Lord, we are so grateful for this well-considered judgment. We also want to thank my Lord profusely for my Lord's patience with us, my Lord's indulgence to us, and then the industry that my Lord has put into this judgment. We are very, very happy, and we are very privileged to have appeared and done this matter before you. May please the court. Thank you. Thank you.
Thank you.
My Lord, we are most grateful for the well-considered judgment.
You're sorry.
Thank you.
So you will have copies next week so that you look at them.
The court, please.
Thank you.
Thank you.
All right.
Thank you.
We wish my Lordship a well-rested vacation.
Same here, my Lord.
Incoming voice call from Hamman.
Do you love me now?
What's that? Problem 24.